argument first this morning in original case 143, Mississippi against Tennessee. Mr. Coughlin.
Mr. Chief Justice, and may it please the Court. The Court should reject the Special Master's conclusion that equitable apportionment is Mississippi's sole remedy, because it's a remedy that redresses the wrong injury. Mississippi does not claim that defendants are taking more than their fair share of groundwater. Rather, Mississippi's case turns on a different question. Do defendants have the right to control groundwater while it is located within Mississippi's sovereign territory? And the Court has answered this question in Tarrant Regional Water District versus Herman. There, in considering an interstate surface river that had already been apportioned, the Court recognized an injury other than that of an upstream state harming a downstream state by taking too much water. Specifically, the Court recognized that one state may not divert water from another state's sovereign territory absent a waiver of that sovereignty. And here it's undisputed that Tennessee is diverting groundwater from Mississippi without Mississippi's permission. And they do so knowingly. In the 1960s, the U.S. Geological Survey warned them it was happening. But rather than stop, defendants opened new well fields within 3 miles of the border and substantially increased their pumping. As of 2014, when Mississippi filed its complaint, they had suctioned more than 400 billion gallons of groundwater across the border. They've increased the cost of Mississippi's own groundwater pumping. And by their own admission, defendants' pumping is draining an overlying surficial aquifer that record evidence indicates is pulling contaminants down into the aquifer at issue in this case. Now, the Special Master, in reaching its conclusions, asked whether the Middle Claiborne Aquifer was an interstate resource. This was the wrong question to ask, because the answer doesn't matter. Even if the aquifer is an interstate resource, Mississippi still possesses sole and exclusive control over groundwater within its sovereign territory, as recognized in Tarrant and ensured by the Constitution. And defendants cannot force groundwater across the border without violating this sovereignty. I welcome the Court's questions.
We'll hear argument next in case 20-5279, Wooden versus United States. Mr. Kedem.
Mr. Chief Justice, and may it please the Court. As its name suggests, the Armed Career Criminal Act singles out the most intractable offenders for the harshest punishments by
We'll hear argument first this morning in case 2826, Brown versus Davenport. We'll hear argument next in Hemphill versus New York. Mr. Fisher.
Mr. Chief Justice, and may it please the Court. A defendant cannot lose his right under the Confrontation Clause to exclude testimonial hearsay simply by making a legitimate defense based on admissible evidence. And that
We'll hear argument first this morning in Isleta del Sur Pueblo versus Texas. Mr. Martin.
Mr. Chief Justice, and may it please the Court. The question this case presents is whether the Restoration Act subjects the Pueblo to Texas's time, place, and manner restrictions as it relates to games that Texas does not flatly prohibit. It does not.
hear argument next in 21A240, Biden, President of the United States versus Missouri, and the consolidated case. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the court. Hospitals vulnerable to COVID-19 in settings that are especially conducive to the spread of the virus.
We'll hear argument next in 21A240, Biden, President of the United States versus Missouri, and the consolidated case. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the court. Hospitals, nursing homes, and other Medicare and Medicaid providers serve patients who are especially vulnerable to COVID-19 in settings that are especially conducive to the spread of the virus. The Secretary required those providers to make sure that their staff are vaccinated, subject to medical and religious exemptions, because he found that vaccination is the best way to prevent workers from infecting their patients with a potentially deadly disease. He also found that any delay in implementing that requirement would cause preventable deaths and severe illnesses. The preliminary injunctions in these cases are delaying that urgently needed protection for Medicaid and Medicare patients in half the country. This court should stay those injunctions for two reasons. First, requiring medical staff vaccination during a pandemic falls squarely within the Secretary's statutory authority to protect the health and safety of Medicare and Medicaid patients. Vaccination requirements are a traditional and common way to curb the spread of infectious disease. Many healthcare workers are already required to be vaccinated against diseases like hepatitis, measles, and the flu. And the medical community overwhelmingly supports COVID-19 vaccination requirements, which have been adopted by providers around the country. Those requirements are, in short, the paradigmatic example of a health and safety measure. Second, the Secretary's decision was thoroughly explained and supported by the record. The states do not seriously deny that requiring vaccination will save lives. Instead, they predict that it will cause staffing shortages, especially in some rural areas. But the Secretary carefully considered that concern. He explained that experience from around the country shows that most workers actually will choose to be vaccinated rather than to leave their jobs in response to vaccination requirements. And he concluded that the risk of some temporary staffing shortages is outweighed by the urgent need to protect all Medicare and Medicaid patients during a deadly pandemic. Congress assigned those quintessential predictive and policy judgments to the Secretary, and the states have identified no basis to disturb his conclusions. I'd welcome the court's questions.
Counsel, are you relying on 1302A?
The Secretary invoked, that's the Secretary's general rulemaking authority under the Social Security Act, and he invoked that general rulemaking authority as he typically does when he makes rules under the Act, but we're not relying primarily or on that. We're instead relying on specific authorities as to each category of covered providers that allow the Secretary to set standards that set the requirements for their participation in Medicare and Medicaid.
I don't understand what you just said.
I'm sorry. The answer is yes, but not only on 1302. We also have specific statutes that speak to each of the covered providers here.
So if I look at the language in 1302, which says that the Secretary shall make and publish such rules and regulations as may be necessary to the efficient administration of the functions with which each is charged under this chapter. You say there is more than that authorizing the Secretary?
Correct, yes.
What is that more?
So the more is set forth. It's different as to each category of providers. So take hospitals. There, the additional authority is in Section 1395X(e)(9), which authorizes the Secretary to set such requirements as he finds necessary in the interest of the health and safety of patients in Medicare and Medicaid. The Secretary cited other similar requirements that authorize him to set conditions of participation for each of the categories of providers, for nursing homes, for ambulatory surgical centers. All of those categories of providers are subject to similar requirements that say the Secretary gets to determine the requirements for their participation in Medicare and Medicaid. The Secretary has long relied on those specific statutory authorities to set forth detailed conditions of participation that are in the Code of Federal Regulations. And what he did here was say, I'm going to add an additional condition of participation pursuant to those specific authorities for each category of provider requiring vaccination against COVID-19.
Has that been used in the past, the argument or the authority that you just set out, Has that been used to require vaccinations in the past?
It has not, no. But the Secretary explained why not. He explained that this is a unique pandemic where we have unique access to effective vaccines. So he explained that in other settings, healthcare workers are typically vaccinated against communicable diseases because they got them during childhood when all of us did, or because state authorities have required vaccinations. But this is a uniquely deadly pandemic that because it is so new, those requirements haven't caught up and ensured the level of staff vaccination that you see in the context of other diseases. And that's why he found it necessary to step in with this requirement.
One last, just a question. Don't you think it's a bit curious that you're placing significant reliance on a provision that speaks about necessary to the efficient administration to administer a vaccine that could have significant health consequences?
Justice Thomas, I don't. So first of all, I just want to be clear again, I'm not claiming that that general authority alone would authorize the vaccination requirement. We're resting on the conditions specific to each category of provider, the vast majority of which, the ones covering 97% of the workers affected by this rule, specifically reference conditions aimed at health and safety. I think when you look at it in that context, it's clear that this is a paradigmatic health and safety requirement.
Counsel, in which case is the relationship between the agency closer to the COVID-19 danger? In this CMS case that you're arguing before us now, or in the OSHA case that your boss just finished arguing?
I think they're different cases. I think it's hard to say which one is closer. The OSHA case, the OSHA Act gives the Secretary of Labor responsibility for workplace safety, and you just heard why the COVID-19 pandemic is a grave threat in the workplace. CMS has authority to protect the health and safety of patients in Medicare and Medicaid, and explained at length why the COVID-19 pandemic is an acute danger to patients in that setting. So I think they're both very close.
Well, maybe it expands it. Which is a more acute danger, OSHA, CMS, or the federal contractor vaccine mandate?
Well, I think all of them. I think this gets to the question you asked my boss earlier, which is, the government is doing a lot of things in response to the pandemic, and I don't think that's a surprise. This is an unprecedented pandemic that touches virtually every aspect of American life, and so it does affect the authorities of lots of different federal
Do you think
agencies.
the government has picked the three most pressing areas to address? They're doing it in order? Or why OSHA, why CMS, why federal contractors, why not any host of other areas that are also, where COVID-19 is also a serious problem?
Well, because the federal government is, as some of the questions earlier had suggested, a government with limited powers. The federal agencies have the authorities that Congress has given them. Congress has made OSHA responsible for workplace safety. Congress has made CMS responsible for Medicaid and Medicare patient safety. And those agencies have determined and explained to their conclusions why those authorities are called upon here by the sort of unique threat that the COVID-19 pandemic poses in both contexts.
I thought you might have said, and it may have been uncomfortable, but I thought you might have said we're dealing here in this case with healthcare, with Medicare and Medicaid. And what could be closer to addressing the COVID-19 problem to health than healthcare? I mean, people already get sick when they go to the hospital, but if they go and face COVID-19 concerns, well, that's much worse. On the other hand, OSHA, it's workplace. Yes, COVID is a problem in the workplace, and in some situations it may be a more serious problem. But it seems to me that if any of the three that I've been talking about anyway present a close connection, it would surely be between a health threat like COVID-19 and the government's health care.
Mr. Chief Justice, I certainly don't want to disagree with that at all. I think there is an acute threat that COVID-19 poses in healthcare settings. We've seen that throughout the pandemic, especially in nursing.
And in the other case, that's why I say decide in each case.
We'll hear argument next.
Set conditions for participation, and our view is that
The party states in the same position.
and safety, the preceding provisions say things like you have to be staffed by doctors, and the doctors have to have particular licenses. You have to have a certified nurse on duty 24 hours a day. You have to have a budget plan that meets the requirements of another subsection.
Okay, so that doesn't control. But somewhere along the line, you move from general regulations that
outline things you, the hospital, have to do to somewhere more directly where you are controlling or supervising. We agree? Yes. There's a sliding scale in there.
I'm not sure about sliding scale. I would say standard setting, we can tell from that context.
There's a range. Can we agree on that?
Sure.
Okay. Where's the line?
I think that as often the case with ranges, the line may be hard to draw when you get out towards more granular controls. I think what I can be confident about is that this standard is on the right side of the line because it's consistent with standards in the statute itself that say you have to hire physicians and nurses that meet these qualifications, or with other provisions that say you have to train, your staff must be trained in this way.
I understand that. What do we do about the fact that Congress has never, the CMS, not Congress, we don't have Congress here, CMS has never before said among its standards a vaccination requirement or any other health standard with respect to employees and actions they must take outside the work environment. So, for example, could CMS also implement regulations about exercise regimes, sleep habits, medicines and supplements that must be ingested by hospital employees in the name of health and safety, and with the government arguing that does not control the tenure of those employees?
I'm not sure that we can be involved with those requirements.
Yes, more refill, some more ice.
More ice.
Yeah, I got Southern or regular Arizona tea, the Mississippi kind of with the Mississippi backlash splash black on the back of the Arizona tea, and then also the regular Southern. Oh, Palmer golfing tea. There's a half and the original Southern. I take both of those. I use both of those. Is there preference? I got the golfer one, half and half, and I got the Southern back splash with the Mississippi. Not the boating kind of, with the gigantic blades in the back.
Yeah, I'm not actually familiar with the teas too much. I just, when we've gotten Arizona tea, it's just like
I get the original Arizona tea, and it's really good. I mean, which one did you want, the half and half, or you want the original?
Probably the original.
Okay.
We can add whatever we think too.
Got it. Got it.
And then on the question, to follow up on Justice Gorsuch's question, what is the story, as you understand it, for why CMS has not previously required flu shots for healthcare workers or some of the other vaccines that, as you pointed out, the states still insist upon for healthcare workers? Is there a story there or explanation there for why CMS has not previously done that?
I think the Secretary laid this out and sort of identified different reasons as to different categories of vaccines. So as to some, where state vaccination requirements mean that everyone is basically vaccinated, does not setting standards, even if they're outlandish standards that we think couldn't be set for other reasons, wouldn't be controlled.
Still doesn't control even though they have to take these medications, they have to get this much sleep, they have to do this much exercise every day.
Anymore, again, I want to be clear, I'm not suggesting the Secretary can do any of those things. I'm just suggesting that the reason he can't is not 1395.
Because it doesn't constitute control of an employee's tenure or compensation.
Correct, because setting standards for employees does not exercise control.
Justice Kavanaugh? You mentioned at the beginning that the over $1 billion in costs would be borne mostly by the federal government, I think you said. Can you explain that?
Sure. I think in large part by the federal government. So the Secretary, in estimating the cost, said a big driver of the cost was going to be the cost of the vaccinations themselves, the shots, and the cost of administering the shots. The Secretary explained that he was including that in the cost-benefit analysis to be comprehensive about the effects of the rule, even though the federal government covers the costs of vaccines for most employees and would cover them here.
Okay. And then on the question, to follow up on Justice Gorsuch's question, what is the story, as you understand it, for why CMS has not previously required flu shots for healthcare workers or some of the other vaccines that, as you pointed out, the states still insist upon for healthcare workers? Is there a story there or explanation there for why CMS has not previously done that?
I think the Secretary laid this out and sort of identified different reasons as to different categories of vaccines. So as to some, where state vaccination requirements mean that everyone is basically vaccinated against those diseases already, there was no need for the Secretary to do that. The Secretary also hasn't acted with respect to flu vaccines. Some states have done that, not every state has done that. But the Secretary explained that this is a pandemic that is a much graver threat than the seasonal flu is, and also that these are uniquely effective vaccines, and explained that it's that combination, the sort of unique pandemic situation that we haven't seen before, and the uniquely effective vaccines that led him to choose to adopt that here.
Thank you. Justice Barrett?
Are you arguing with respect to the facility-specific grants, and this goes back to the questions that Justice Sotomayor asked you after we last talked, are you arguing that those facility-specific grants inform the general grants in 1302A and 1395HH, such that we should interpret the general grants as encompassing the authority to impose health and safety measures? Or are you arguing that even if we pretend that these two general grants don't exist, that the facility-specific grants would nonetheless equip the Secretary with this authority?
I think the latter. I think I'd be making the same argument even if we didn't have the general grant. I think the general grant reinforces the idea that when the Secretary sets standards, he has the power to do that through regulations, but we're relying primarily on the specific grants, and I think those would be sufficient even if you set aside 1302.
Thank you, Counsel. Mr. Osete?
Mr. Chief Justice, and may it please the Court. In early 2020, while millions stayed at home, millions of healthcare workers heroically stayed at work. These same workers are now forced to choose between losing their jobs and complying with the government's vaccine mandate. The Secretary's claim of authority to impose this mandate is expansive, unprecedented, and unlawful for two principal reasons. First, the Secretary believes a series of vague catch-all provisions scattered throughout the Social Security Act authorize this sweeping mandate, but the relevant text, structure, and context say otherwise. For example, the Secretary ignores 8 provisions that precede the catch-all provision he primarily invokes, all of which are materially unlike a permanent medical procedure that cannot be undone after a shift is over. Exceedingly clear language is required here because the mandate regulates matters that have traditionally been within the province of the states. Second, the rule is arbitrary and capricious under the APA. The Secretary impermissibly extrapolated evidence for one category of facilities to justify regulating all 15, and failed to adequately explain his sudden shift from encouraging vaccination to mandating it. But more fundamentally, the Secretary overlooked the critical perspective of rural healthcare facilities in the states and the devastating consequences the mandate will have on rural Americans' access to healthcare. Categorically excluding an entire class from employment will mean that patients in rural Nebraska will have to seek primary and emergency care 2 to 3 hours away and cannot undergo surgery. This represents vast stretches of this country where healthcare is not provided by massive institutional providers with tens of thousands of employees, but by smaller healthcare facilities run by local communities. While a 1% loss of staff may be insignificant to the former, it is fatal to the latter. Without the injunction, rural America will face an imminent crisis. The government stay application should be denied, and I welcome the Court's questions.
Counsel, would you discuss the preemption issue just briefly?
Yes, Your Honor. This regulation, the Secretary says in this regulation that it is intended to preempt arguably any inconsistent state laws with respect to vaccination requirements. And for example, in this case, the most direct example I can point to, Your Honor, is at 20-7-134 of the Arkansas Code that prohibits as a condition of employment any sort of vaccination requirement.
But that's somewhat ironic since the government relies on those other vaccinations to argue for this vaccination. But are all of the party states in the same position with respect to preemption?
Your Honor, certainly the district court in this case, at the very least, cited that Arkansas, Wyoming, and Missouri are similarly situated with that respect, and certainly there are other states in the Missouri-led coalition that also have laws that are going to be preempted by this regulation. The key point here, Your Honor, just like in Mass EPA, is so long as one of us has one of these laws that would affect our duly enacted legislation through an unlawful mandate, it does present an issue on preemption. Now, that's independent, obviously, from other interests that the states have in this case, which is the states are the administrator. It's our providers with respect to Medicaid, with Medicare. We're being asked to facilitate this program for the federal government. We have compliance costs. We have surveyors who have to go out and enforce this rule. All of that are the state's interests, Your Honor.
Well, the one final point has to go to standing. You seem to rely on parens patriae a bit. And would you discuss that standing and why we should apply that?
Well, sure, Your Honor. And just to be clear, we do have various capacities here. We mentioned sovereign interest. We mentioned proprietary, a whole plethora of them. And certainly we did invoke also a quasi-sovereign interest in the health and well-being of our citizens. For example, this mandate will close the doors of many of these rural facilities that will effectively deprive our citizens of health care. And we also are asserting rights under federal law with respect to the APA on many of these claims. But that is not the only basis that we're seeking standing in this case. We have various other capacities that we're suing under, just like the ones I mentioned, Your Honor.
Is that true of all of the parties?
I believe so, Your Honor, yes.
Thank you.
There was a question. Sorry, Chief.
No, I was just going to ask you about the spending clause context. In other words, we're not just dealing with federal law in the abstract. We're dealing with a provision that says Congress authorized the Secretary to ensure compliance with requirements that the Secretary finds necessary in the interest of the health and safety of patients. That's very broad, and I think, will you agree that they have broader authority because it's in a spending clause provision? I mean, you signed the contract.
Well, sure, and even in the spending clause, I would say two responses to that, Your Honor. First, even in the spending clause context, as Justice Alito mentioned earlier, the states are entitled to clear notice. So there is, whatever conditions the Secretary does state, they have to derive from unambiguous grants of statutory authority. And in this case, Your Honor, we respectfully disagree with my friend, Mr. Fletcher, because he only cites certain parts of these provisions. For example, with respect to the hospital in this application, he ignores the such other requirements language that precedes the Secretary's authority to regulate health and safety. And many of those provisions, for example, E1 through 8, none of those talk about immunization. They talk about record keeping. They talk about discharge procedures. They talk about
Mr. Rossetti, really, do you think that the CMS head and that the Secretary of HHS are bookkeepers with respect to this statute? Do you think that they don't have responsibility to protect the safety of these two incredibly vulnerable patient populations? Isn't that their principal responsibility?